Good afternoon, everybody. We're going to go ahead and get started. We do have a lot of content that we're going to cover today, and it is a fairly dense topic, so I'm going to kind of breeze through some things really quickly. The first thing, I just wanted to make a quick announcement. It's not in the slides, but hopefully everybody was on the listserv messages from last week about our upcoming Research Community Forum. It's an event that we're co-hosting with the Office for Human Research Protections. It's going to be at the Irving Convention Center, so if you know where Las Colinas is at and you've driven by that convention center, that's where it's going to be held at. It's going to be held on April 7th to the 8th, and if you have any questions about getting registered for the conference, just shoot an email to myself, to Rhonda. We also have a general email address for that as well. So just feel free to get registered, ask us any questions, but we're super excited about that particular conference. So we're going to use the clickers again, and it's the second time we've used them, so if there's any technical difficulties, bear with me. But like I said, we're going to be talking today about metrics, and we're going to be talking through waivers of informed consent and HIPAA authorization. And that's a fairly dense topic, so I'm really just going to kind of show, here's the metrics for 6 months and 30 days. Here's our full board turnaround times, and just one plug, we did expect and we always see an increase in turnaround times because of the holidays. Hopefully you're taking time off. I know that people within the HRPP took time off. We also had a period where we did not have any IRB meetings for 2 weeks because of the way that the holidays fell and the way that the state set the holiday schedule. So this is a little bit of an expected bump because of everything that's happened. Here's expedited, exempt, and again, I'm just kind of going through these quickly so that we can get to the meat of the presentation. And here's reliance. Okay. Any comments or questions really quickly before we dive into our topic? Okay. So let's see if this works. So informed consent and HIPAA are governed by the same regulations. So make sure that you turn on your clickers. The frequency code is AA. I don't think that you'll actually have to set that, but follow these instructions. And if everybody's followed these instructions, I'm going to start it up. Wow, okay. So it's working. So it's true and false. I don't know how many clickers we handed out, but when we get to about 50-ish answers, we'll go to 20 seconds. How about that? Don't worry, we can't tell if you're right or wrong. This is completely de-identified. This is exempt research. Okay, so 36% of you thought that it was true, and 64% of you said that it was false. So we'll get to what the correct answer is in just a second. Let me pop that back down. So informed consent and HIPAA authorization. So the federal regulations actually require that informed consent and HIPAA authorization be obtained from research subjects. And informed consent is governed by 45 CFR 46.116. So if you take these slides home and you actually Google that information, you will find the exact text regarding informed consent, what the requirements are, what needs to be done to obtain proper informed consent. And HIPAA authorization, it's 45 CFR 164.508. So they are different regulations. And we'll get more into why that matters in just a couple slides. But ultimately, informed consent and HIPAA authorization, different regulations. And with informed consent, what the requirements are is that before involving a human subject in research covered by this policy, an investigator shall obtain the legally effective informed consent of the subject or the subject's legally authorized representative. So normally I'm not a big read off the slide sort of person for presentations, but I think that this is really important information just to kind of highlight. So informed consent has to be obtained before we involve subjects in research. And I just also wanted to throw out the definition because in this slide they say involving a human subject. And a human subject, according to these regulations, It's a living individual, so that's really important. When we're talking about the research regulations specifically, we're talking about people who are alive. The research regulations, when it comes to OHRP, that's where these regulations come from. This is also the common rule. If you did not know this was common rule, it's only going to regulate research with living individuals. And it's about whom an investigator obtains information or biospecimens through an intervention or interaction, or obtains, uses, studies, analyzes, or generates identifiable private information or identifiable biospecimens. So that's two very distinct activities. The first one means that I'm potentially doing a survey study, and I may not actually be getting any private information, but because I'm interacting with the subjects, I'm changing their environment by having them take the survey. This is considered human subjects research. The second option is really referring to you're looking at identifiable private information or identifiable biospecimens without necessarily interacting with the subject. So this is why chart reviews and looking at biospecimens that are coming out of the registry where you have identifiable data is considered to be research. Now, I also want to point out really quickly that this definition does not necessarily say private health information, the same way that HIPAA defines PHI. This is identifiable private information, and identifiable private information is information that would allow an investigator to reasonably identify the subject. So if I tell you that there was a subject who had a CAT scan here on campus on December 2nd, 1980, that doesn't mean a whole lot to anybody, right? CAT scan, okay, so we have a medical test and we also have a date. According to HIPAA, that's going to be identifiable. We have a date. According to OHRP's regulations, that's not necessarily identifiable because for most of us, we have no idea who that patient is. And so the ability for us to then identify who that was, we're going to have to go through a whole lot of steps to figure out, okay, who had a CAT scan on December 2nd in 1980? And then, of those people, who potentially are we talking about? Because I guarantee that we did a lot of CAT scans in 1980, or I'm guessing that we did. I don't actually know. With HIPAA authorization, so what they define is that we have to obtain an authorization before the covered entity, and that includes all of you as employees of the covered entity, may not use or disclose protected health information without an authorization that's valid under this section. And when I read through the regulations on research are much clearer to me, at least in terms of how they read, than the HIPAA regulations. And maybe it has something to do with the fact that really the core of the information on the common rule was written in 1991, and this was written later, more towards like 2005-ish. And so maybe there was a lot more lawyers involved in the HIPAA regulations, and they said, well, let's throw in a bunch more words here to make it confusing. Maybe it's just because I'm much more familiar with the common rule regulations, but ultimately there's a lot of language on this slide, and it's really just saying that before you use or disclose PHI, you have to have an authorization. So just want to leave this sort of section to make sure we all understand it's two sets of regulations, which means also we have two sets of regulations on the types of waivers that an IRB or a privacy board can approve. And that also means that there's potentially two sets of requirements that are unique regarding what the IRB or the privacy board has to satisfy in order to approve those waivers. So that's why I really wanted to start off with that first question to drive home the point that these are different regulations. And when you submit your studies to us, that's why we're asking both questions. Are we waiving informed consent, and are we waiving HIPAA authorization? Okay, any quick questions before we move on? Okay. So we'll start off with informed consent waivers or alterations. So if informed consent can be obtained, the IRB cannot approve a waiver of informed consent. True or false? 5 more seconds. We got a lot more responses on this one. Okay. So 23 of you thought that that was true, and 56% of you thought that was false. So the correct answer is that it's false. The regulations do not necessarily ask whether or not informed consent can be obtained, and we'll get into that in just a second. So with informed consent, when we look at the OHRP regulations, there's a lot of different types of waivers. And I messed up my formatting here, but it's all right. So ultimately, we have a general waiver or alteration of informed consent. We have a waiver or alteration for screening, recruiting, determining eligibility, a waiver of documentation of informed consent, a waiver or alteration of research involving public benefits or service programs. We don't see a lot of that sort of research here at UT Southwestern. A waiver of consent for emergency research, and we do have one or two of studies that fall underneath this sets of regulations. Most of our emergency research where we waive informed consent is actually under the FDA, and I just tried to steer clear of FDA for this particular talk. And then we also have a waiver of assent or parental permission. And you can see I also threw in there that when we're talking about general waivers or alterations, we have Form G1, and we'll get into why I'm referencing Form G1. With waiver of documentation, we have G3 on our website. For waiver for 4 and 6 on the slide, we really don't have any pre-filled out templates. Again, we don't do a ton of research for public benefit or service programs. And with waiver of assent or parental permission, that's going to be really study specific. So it'd be hard for us to come up with a good template document that somebody could use to submit a waiver of assent or parental permission. And we do have a waiver of consent for emergency research template. It's not necessarily pre-filled out, but because you'll see in just a second the requirements are different, it's a different form. So if you're ever going to be doing a study where you need to ask the IRB to waive informed consent in an emergency situation, as part of the standard plan for the study, not just for one subject, start with Form G4, because that will ask you the appropriate questions. Okay. And I also just want to point out, so I said waiver and or alteration quite a bit on that slide. And the way that these are defined within the regulations is that a waiver means that the IRB is waiving the requirement to obtain informed consent. So we've said this study is not going to obtain informed consent for some reason. And an alteration means that we're actually taking parts of the requirements that are described in the regulations, or we're taking some of the elements and we're altering the consent process, so we're not going to include it. A really good example is a study where we're doing some sort of survey research, and we alter the informed consent process, so we're not necessarily talking about risks, we're not talking about costs, and we're not talking about some of those elements of informed consent that may not really apply to this survey study. If we can get that consent form so that it's this long and everybody's able to make a much more informed decision because they're not wading through a bunch of text that really doesn't apply. For example, there are no costs associated with the study. If there are no costs associated with the study because it's a survey, the IRB can waive the requirement for you to talk about costs in that document. And then that means that maybe the document's easier for everybody to read. So, here is that general form where you fill out waiver of informed consent, an alteration of informed consent, or a waiver of documentation of informed consent. Make sure, this is one of the most common things that I see when I'm doing designated reviews, you're filling out what your STU number is here in the document. So if you didn't notice that some of our forms have that on there, most of the forms have that field in there. Make sure you're filling it out. So with a general waiver or alteration of informed consent, again, that really just waives or alters something about the informed consent process. Generally, the general waiver or alteration of informed consent, pretty much waiver, is going to apply to chart review studies. We're not going to obtain informed consent. And what we have to find and document, so the regulations are very specific, that it's not just that the IRB has to waive informed consent, but the IRB must find and document that these requirements are met. So that's why we have these forms which ask these questions. So the research cannot be more than minimal risk. So when we're looking at waiving or altering informed consent, the research has to be minimal risk. So if you're looking at a more than minimal risk study and you are thinking about altering that informed consent document, we cannot do that. All of the elements that are required for that consent have to be there. We can't waive that or alter that consent process. And inside Form G, here's that question. So for all requests, describe how the research or the risk in this research is minimal. The research could not practicably be carried out without the requested waiver or alteration. So for those of you who know people that work within the office, Erica Sawzik is our amazing administrative person. She does everything for us. She was reviewing my slides this morning and she said, is practicably really a word? It really is a word. It's right in the regulations. I'd never seen it before I read the regulations the first time I ever did an IRB job, but yes, practicably is a word. And what that means, and the reason I asked the question about is if informed consent is possible, the IRB cannot waive that requirement, is because there's a lot of people around the country who look at this requirement and they misinterpret it. They read it as, if informed consent is possible, informed consent must be obtained. But that's not what this is saying. This particular language is saying that the research could not be carried out unless the waiver is approved. So if we're talking about a study where you need to look at charts, you may not be able to contact everybody whose chart you're going to be looking at. If we're talking about an epidemiologic study, and the having patients say no to having their data collected might bias the study results. That's an appropriate justification. Now the research is not practicable. We cannot conduct the study. And so ultimately the way that we kind of break this down inside Form G is design issues or feasibility issues. Design meaning that we might bias the study results. We can't conduct the study. Feasibility meaning that we just don't have the ability, the resources to obtain informed consent. And that might not necessarily be coordinator time, that might be contact information. I guarantee that my information in Michigan, at all the places that I was ever treated in Michigan, has been used as part of a chart review study. And I guarantee that none of those health organizations have my current contact information because I have changed phone numbers since I was in college. So how are they ever going to get in contact with me? They certainly don't have correct addresses because both my mother and my father have moved, and I definitely don't live on my college campus anymore. So that's the sort of information that, we have a lot of patients in our medical records, and they're not calling us every time they move or every time they change their phone number. So continuing on with what the IRB must find and document, the research could not be carried out without using identifiable private information or biospecimens. So this is actually a new requirement with the new common rule. Before, the common rule did not really talk about the use of identifiable private information or biospecimens. And so we really just have, why do you need access to that sort of information? And the waiver will not adversely affect rights or welfare of the subjects, so we're not going in there and we're not affecting their ability to receive health care here. We're not going to alter their future health care or anything like that, and being pretty specific to health care, but ultimately what happens if we get data about a subject and it means they could never be employed again? Well, that could potentially adversely affect the rights and welfare of the subjects, which then we'd want to make sure there's an appropriate confidentiality plan for the study. Yes, I did mean to say in the first bullet point without using. Thank you for catching that. And then, not adversely affecting rights and welfare of the subjects, right there. And then lastly, that the subject or the LAR will be provided with pertinent information when appropriate. It's not often that the IRB finds that something would be appropriate to return to the subjects. I honestly, in the 10 to 11 years I've been doing IRB work, I've never seen a study where I've said, you have to give this information back to the subjects. if I'm actually considering waiving informed consent. So it's there, I've never seen a study where that's really been appropriate, but we have it there so that you can answer that for us. So I mentioned when we were going through the types that we had the templated form. So this is G1, which is the waiver of informed consent. And I just want to point out, I know that when we went through the whole EIRB Lite Go Live process and we talked through the documents, I mentioned we had these templates, but maybe now that we're going through the waivers just themselves, you'll see how valuable our templates are. So if we're doing a chart review study, we've already given you the answer for why that chart review study is considered minimal risk. We've also given you the answer about why the rights and welfare of the subjects are not going to be adversely affected. Now, obviously, the information in this template is specific to a chart review study, so don't use this language if you're doing another type of study where you're asking for a waiver, but it's still valuable information. You know what our expected answer is for a chart review study, and so maybe you can use this information and figure out what the answer should be for a different type of study. So that's the reason why I think these are so helpful. We give you the answer of why it's not practicable to carry the research without the waiver or alteration. And we also give you the answer of why you need access to the identifiable private information or biospecimens. And then you can see for our chart review template, we just put not applicable for are we going to return any results back to the subjects? Because it's usually not that appropriate. Any questions on waivers of informed consent? Okay, so moving on. When we're talking about screening, recruiting, or determining eligibility, so under the old common rule, if you are going to be looking at private identifiable information, going back to that definition of a human subject, so you're going through a subject's chart and you're saying, yes, they're eligible for my study. Now I'm going to give them a call and let them know about the study that I have. Well, you've looked and interacted with, you've analyzed, or you've done any of the things that were in that definition with their identifiable private information. So under the old common rule, the IRB had to waive informed consent for recruitment. But you already have access to this data, and or you might be calling a subject and having them answer a couple questions for you, essentially doing a survey for screening. And with the new common rule, the federal authorities have really recognized that you already have access to the data, or if you're calling and talking to the subjects and doing some sort of screening questionnaire and they answer the questions, aren't they just giving you consent, essentially? They're saying, oh yeah, I'll answer your questions. Okay, yeah, that sounds great. I'd love to be in the study. Sounds like I'm eligible. So now under the new common rule, the IRB no longer has to approve a waiver of informed consent if you're looking at information or biospecimens by talking through or by talking to or working through written communication with the subject or the LAR, or you're obtaining information from the records or stored biospecimens. So what's really important here is that you're not producing new biospecimens. You're not going, to a clinic visit and asking the subject, can I just get some extra blood? And then we're going to look at what's in your blood and determine if you're eligible. That would need a waiver of informed consent or informed consent. If you are just looking at, that they've participated in Dr. Lewis's registry study in the Cancer Center, and that you could get some blood from there and analyze that, you can do that without a waiver of informed consent. So if you've seen an EIRB, we still have the option for you to select waiver of informed consent in EIRB Lite and then upload a placeholder. It's because we still have a lot of studies approved under the old common rule where we did have to waive informed consent. And because EIRB cannot replace the smart form and have it be not forward compatible or backwards compatible, we have to keep that option there. So that's why we ask you to upload a blank placeholder if you're doing screening. I know that's a question we get a lot via email or over the phone. Why do you ask for a document when it doesn't really mean anything? And it's really just because of the new common rule. So moving on to a waiver of documentation. So the IRB can waive the requirement to obtain signatures. So a lot of times in research coordinator vernacular, this is verbal consent. Again, for all waivers, the research has to be minimal risk. So we cannot approve a verbal consent when we're talking about a more than minimal risk study if you're asking for verbal consent for the entire study. We could consider waiving documentation if we're only waiving documentation for specific research procedures. For example, maybe fasting. You need subjects to come into the first visit and not having ate anything that day. That's pretty minimal risk. Unless you're my wife, and then that's not minimal risk. She'll never see this video, so it's okay. But ultimately, that's a pretty minimal risk thing, and are we really gonna ask the patients to come into a clinic visit, sign informed consent, and then go back, start fasting, and then come back in the next day? That's a lot of burden for them. We could just call them and say, we've got a research study, you're coming into the clinic tomorrow, we'd love for you to fast if you're interested in potentially finding out if you're eligible. So again, the same question applies for all requests. Describe how the risk in this research is minimal. And then for waiver of documentation, informed consent, or verbal consent, there's 3 additional justifications. So the first one that the IRB could find for your particular study is that the consent document would be the only link between the subject and the research. And really the principal risk of the research would be the loss of confidentiality if the data ever got out. So this really mostly applies for survey studies. If we had subjects fill out an informed consent document and tie their name to the research study, and in particular to the individual survey that they filled out, and the survey contains sensitive information, we've actually now increased the risk of the study for them. Whereas if we just had them fill out the survey without ever documenting it was this person who filled it out. Or the IRB could find that the research involves no procedures for which written consent is required outside of the research context. So I like 2 examples when I do education on this particular topic. So I've talked with Kate before, and I've asked her, she bought a house last year, and I asked her about her child, and I've asked her about her personal life. And really, if you think about it, that conversation is like a survey. We just don't think about small talk as a survey. But I'm obtaining information from her, and she's willingly giving me that information. And I never asked her, hey, Kate, can I have your consent to have some small talk right now? Right? Like that doesn't happen in real life. So that's the sort of procedure that does not require consent outside of the context of research. An example that some of you may not agree with, but it's true. The last time you were at your doctor's office, your primary care physician's office, and they said, hey, we need to draw some blood, check your triglycerides and your HDL, LDLs, they never got informed consent for that specific procedure, right? You signed informed consent to receive treatment, but you did not sign a specific informed consent for that blood draw. So theoretically, a blood draw could fall underneath this particular waiver of documentation. We don't get informed consent specifically for blood draws outside of the context of research. Lastly, this is new in the new common rule, and I feel like I might know the study that this was put into the new common rule for. There was a study that was being approved by a central IRB for a cultural group that did not have a written language. And if the requirements from the federal authorities are that you obtain informed consent on a long form or a short form, and the subjects don't have a written language, how do you obtain informed consent? It just wasn't possible. And I don't know how they reviewed and approved that study if they did. But ultimately, that was a real study. It was a population in California that did not have a written word. So this now allows that research to potentially happen if it's minimal risk, and the subjects may come from a cultural group where signing their name is not the norm or has connotations in their culture, or they don't have the written word in their particular language. Now, for all of these, the IRB can, and usually does, require a written summary be provided to the subjects. So when you're looking at our website and you see our information sheet template, that's really what that information sheet template is for, is you're still telling them and giving them information that they can take home about the study. This is research, it's voluntary, these were the risks, this is what we asked you to do. You're just not asking them to sign it. So inside our Form G, here is the template on how you go about telling us which justification your study would qualify for. And when it comes to requiring a written summary being provided, here is that the plan. Now you can say and propose to the IRB, we're not going to provide a written summary, and that sometimes is okay if we're talking about a study where the only interaction is really a survey and the subjects are going through a link that they got via an email. Maybe you're not providing them a written summary of the information about the study. However, informed consent is still being obtained. That's really important to emphasize. So to be honest, when I talk to people within the HRPP office and they use the word verbal consent, when I'm doing education, I always say waiver of documentation of consent. We have not waived informed consent. Informed consent is still being obtained, and it still has to be documented. The requirement to document that informed consent was obtained has not been waived. We've just waived the requirement of getting the signature. That's actually what the regulations specify. We're not asking the subjects to sign. And so a lot of times we just ask the research coordinators inside Form G that how are you going to document that verbal consent was obtained? And it's super simple, maybe note inside the research file. Talked with these people, got informed consent. And we also have a template, G3, for waiver of documentation. And most of the time, waiver of documentation, when we're talking about it being templated, we have something in here for fasting, but we can waive documentation of informed consent for a variety of other reasons, but our template language really gets down to fasting. Again, that's a minimal risk procedure. This is our template information about giving relevant information when documentation is waived. Oh, so any questions about waiver of documentation? Okay.
I have a question.
Yeah.
So you're saying you basically have a conversation with the patient without patient signing the document and say there's some blood draw from the patient. The patient come back and says, no, I never agreed to that. So how are you going to resolve that issue?
So the question, just to repeat it for the video and for everybody who couldn't hear, so we have a study where you're asking a patient to give blood, and then the patient comes back and says, no, I never consented to participate in the research study. Again, that gets back to informed consent has to be obtained, and informed consent still has to be documented. We're just not getting the physical signature. That's why in Form G, we still ask this question. What's the plan for documenting that verbal consent was obtained? So this is not, we're just going to have a quick conversation, give me some blood, and then that's it. There's still requirements for having an appropriate informed consent discussion and for documenting that process.
So the documentation says, what is the documentation that you guys expect to see?
It's right here.
Such as such and
Yeah, right here. So it says right in the note, on date, subject was provided information about the study, including purpose, risks, benefits, procedures. Subject was provided an opportunity to ask questions and have them answered. Verbal consent was obtained, not obtained to participate in the study. So that even if consent is not obtained, these notes should still be happening. Yeah.
Again, going back, you're documenting that you've done it as a research coordinator, but the patient can say, no, I haven't done it. No, I never agreed to that without their signature. You see what I mean? From the legality standpoint, that issue always exists.
That issue always, yes, so you're right. The patient can always come back and say, no, I didn't consent to participate. But the patients could say that even if we're getting a signature.
But that's a different story.
But it's not necessarily different because they can argue I wasn't in a state of mind to actually understand what was being said. Or, yes, I signed the document, but I was just given the document. Nobody ever actually talked to me about it. So that's why informed consent is always a process, and that process has to be documented. It cannot just be, it's not just a signature on a page. So that issue can always exist even if we're getting the signature on the page. Yeah. Okay, so waiver of consent for emergency research. We're going to go through this pretty quickly because we don't have too much research that falls into it. But this is a life-threatening situation. Informed consent is not feasible either from the subject or an LAR. The research holds out direct benefit for the potential subject. Research is not practicable without the waiver. The research has to define what the treatment window is and then the attempts within that treatment to obtain informed consent. So if I've got an intervention that does not need to be implemented as soon as the patient arrives at the hospital in their emergency situation, then I can wait until an LAR presents or the subject wakes up, right? If I've got an intervention that needs to be done before surgery, and these patients coming in as trauma are going to be going almost straight up to a surgical bay, then you have to have appropriate information about why that treatment window is so tight, something in the literature about this is why I need to do it, and then also define within that context of I've got 30 minutes before the patients are going to go up to surgery, these are the opportunities I'm going to take to make sure that if an LAR has presented, I'm talking to that LAR, or I'm assessing the subject's ability to give informed consent. And with these studies, you also have to do a community consultation process before the IRB gives full approval. So these are very similar to the FDA exception from informed consent studies. And again, just going through it very quickly because we don't see too many of these. And if you ever have a study where you need to do this, I would encourage you to talk with myself or Rhonda. So moving on to a waiver of assent or parental permission. So we'll start with a waiver of assent. And essentially, the IRB could waive the requirement for assent because some or all of the children are going to be so limited in their ability to give informed consent that they really can't give informed assent, that they really couldn't do that. So if we're talking about population where we have a developmental delay, we're talking about children who have been intubated and the research is while the intubation is in effect. We're talking about, newborns. I would still question that my 2-year-old daughter can tell you yes or no, but she's never going to be able to make an informed decision about whether that yes or no is really true. We can also waive the requirement for assent if the research holds out the prospect of direct benefit is only available in the context of research. So having come from a pediatric institution in Chicago, we did see these studies, unfortunately, frequently in cancer studies. And so our investigators would say, listen, we don't expect that we're going to have a child say no to treatment, but we would like the ability to waive assent if a child says no and the parents say yes. That every single one of their studies was set up that way, because unfortunately we did have a child who said no, but the parents wanted their child to be treated. And in that context, the parents, because the research did hold out the prospect of direct benefit, it was not available outside the context of research, and it was really kind of the last line of treatment for the child, the parent's decision held. Or we can just waive the requirement for assent according to the requirements for general waivers. So those 5 requirements that we already went over. With waiver of parental permission, we can waive permission if parental permission is not a reasonable requirement. So if we're talking about research on abused children, I'm certainly not going to go to the abuser and ask for permission. Or, again, with parental permission, we can waive according to the requirements for general waivers. So, next question. Informed consent does not need to be waived for exempt studies. True or false? So the responses are coming in slow. Does everybody understand it? Power? Okay. I wrote this question at 10 o'clock last night, so if it doesn't make a ton of sense. Okay, we'll go 2 more seconds. Okay. So 26 of you thought that that was true, 35 of you thought that was false, so it's true. Informed consent, the requirements for informed consent don't actually apply to studies that the IRB has determined to be exempt. That's what exempt means. It means that the rest of the rules inside the regulations don't apply to those studies. And the reason that we're going over that particular question is because we're about to talk about HIPAA authorizations. And with HIPAA authorizations, that law does not care about the level of IRB review. All HIPAA cares about is that PHI is being used or disclosed on the research study. So that's why when you're going through and you're filling out your exempt chart reviews, you're not even asked about waivers of informed consent. You skip right past that section in EIRB, but you still have to fill out the HIPAA waiver section. And if you didn't realize that you were skipping past the informed consent section in EIRB for your exempt studies, then it worked. That means you didn't even notice it. And so types of HIPAA authorization waivers. So we have full waivers, where authorization is not going to be sought whatsoever, primarily for chart review studies. We have partial waivers, where you're going to identify the eligible subjects using their PHI, but you're only going to keep that PHI until you've been able to talk to subjects. For any subjects who give authorization, you keep the PHI. For any subjects who say no, you get rid of or all of the PHI. So I have a really good example. The first study that I ever worked on was in the ER with car crash victims. We would go through, we would assess whether or not they are eligible for our study, and then we would go contact them to find out if they wanted to participate. And it was a national study, NIH funded, run out of North Carolina, and we had to basically confirm for the NIH that we were screening subjects. So for the subjects who said no, essentially I would say, yes, I saw somebody today, yes, they were in a car crash, no, they didn't consent. There's no PHI there. And in fact, the system where we submitted that through didn't even have a timestamp related with that particular study or that particular study subject, because a date associated with the date of the car crash and the date the subject came into the ER would be PHI. It was just my institution had screened a particular patient at some point. If they gave consent, then I gave the system a lot more information, including PHI, that the subject had given me the authority to collect. And we can also alter authorization. So this changes or omits elements of the authorization. And with HIPAA, one of the elements of authorization is actually the physical signature. So this is distinct from OHRP's requirements, where a signature is not necessarily an element of informed consent. According to HIPAA, this is an element of the HIPAA authorization. This is why when we waive the physical requirement for a signature with HIPAA authorizations, we're altering the process. So with full waivers or alterations, these are the requirements. We can have to make sure that the use or disclosure of the PHI involves no more than minimal risk, and then there's 3 requirements in the regulations. There has to be a plan to protect those identifiers. There has to be a plan to destroy the identifiers at the earliest opportunity, and this really can be defined by the study team. Does this mean before the study is done? Does this mean once the publication has been submitted? This can be defined by the study team. The PHI cannot be reused or disclosed to another person, entity, or for other research. So if we have waived authorization, you can't then reuse that for future research unless we've waived the requirement for authorization for that future research. But then that's a distinct waiver. So that's why if you have a chart review study, you can't just keep using PHI for future research. The research cannot practically be conducted without the waiver alteration. So again, this does not mean that HIPAA authorization is possible, therefore it must be obtained. It means the research would not be practicable, could not be conducted unless the Privacy Board or IRB waived the requirement for HIPAA authorization. The research couldn't be practicably conducted without access to and use of PHI. So this is basically very similar to the new requirements under the new common rule, that you have to get to this level of information. And the IRB has to document the PHI for which use or access is necessary. And we'll come back to this in just a second. So first question, why it's not practicable. It's not necessarily as templated as G1 or G3, but it's still a heck of a lot more templated than other institutions out there. Go out and look at some other institutions. If they have document HIPAA waivers, they don't give you any sort of this information where you can just start and do a checkbox. So then this gets down to the level of information that you're going to be accessing, 3A, 3B, 3C, and then 3D and 3E. I know I went through that quickly, but this gets to that question where the IRB has to know what PHI you need access to. This is why when you're filling this out, you need to be very careful about what information you leave here and what information you put in here. It needs to match the research plan. And this is also why for all chart review studies, we're requiring a data collection form. We need to make sure that if you're getting dates in your data collection form, that right here, we have dates. If it's not there, you don't have the authority to access it. With question 4, this is how long are you going to have access to the information, and it's really all of the 4s are talking about the plan. How are you going to record the data and how are you going to protect it? So again, getting back to the plan. And really this gets down to you're not using it for giving it to other people or using it for future research. You're not giving it to other people or using it for future research. And that you're keeping the information only for as long as you need to. And you're only obtaining the minimum level of information. So that's why sometimes if you get an email from the HRPP office, whether it's from the analyst or the designated reviewer, and they say, you've asked for the MRN, the date of birth, and the name of the subject for a chart review study. You don't need all 3. I would argue, take MRN. That's a very specific identifier for one subject. You don't need the subject's name. I wouldn't start with date of birth because there's a lot of people who were born on 12/2/86 just like me. But MRNs, if it's just an MRN, it doesn't mean a whole lot to people outside of this institution, whereas if you say, oh yeah, I had a research subject, Joshua Fidua, well now they know a heck of a lot about me because at least they know my name. If I give you my MRN number, okay, well that doesn't mean anything to anybody outside of UT Southwestern. So that's why sometimes you'll get the email back. Do you need everything you've put in here when it comes to PHI? And then specifically, I wanted to touch on alteration of HIPAA authorizations when it comes to short forms. So when you're using a short form, the requirements are that you're obtaining, you're documenting consent on the short form, but you're also verbally presenting the English consent document, or as the regulations call it, the English summary. And inside that document is the HIPAA authorization if it's the new combined version. So you're verbally presenting everything about HIPAA to the subjects. And what we can do is we can waive the requirements for a physical signature by altering the HIPAA authorization process, because the short form will not have anything in it about HIPAA, but you're verbally presenting HIPAA to the subjects. So I believe soon, we're just waiting on this to get approved by Web Services, our forms page will have the form H.SF, so that if you need to submit a short form request and consent to subject on a short form, and you have the combined consent and HIPAA authorization, we can waive the requirement for you to get a physical signature for HIPAA authorization. It means that you're just really documenting consent on the short form and the English long form. Makes things a little bit simpler. If you've got if we're talking about Spanish-speaking subject and you have a standalone Spanish authorization, it's obviously far easier for you to use that to obtain HIPAA authorization. And then lastly, partial waivers of HIPAA authorization. So this means, again, getting back to your reviewing PHI to prepare a research protocol. You're not removing any PHI from the covered entity. So you're not sending anything outside of UT Southwestern, Children's, Parkland. They're both covered entities as well. And the PHI is necessary for research purposes. So earlier today, Satish asked or got a question from an investigator saying, I want to use Slicer Dicer to look at de-identified information to confirm that this research is possible. That would not require a partial HIPAA waiver because it's de-identified information. And that's why tools like Slicer Dicer and other things within Epic that allow you to look at de-identified information and figure out if you've got the patient population exist. It protects patients' privacy while also allowing researchers to do their jobs. And then lastly, coding data sets and removing identifiers is a standard method to protect PHI. True or false? So for the 6 of you who said no, feel free to come up and talk to me afterwards. I was lying earlier when I told you that we didn't know who, no, I'm just joking. I don't know who those 6 people are. But in section 27 of EIRB, we ask about a coding plan. And I've looked at some exempt chart review studies in the past week as a designated reviewer, and inside the Excel spreadsheet, the data collection form, there's MRN and then all of the information. But does MRN need to be in that spreadsheet, or can MRN be in a separate spreadsheet coded to the particular study subject, and then inside the true data collection form, you just have the code? The reason that can be super helpful and super important in protecting confidentiality of these patients is that if that spreadsheet has no other PHI, which is pretty common, it's just medical information, and that spreadsheet gets lost, doesn't mean anything to anybody. We don't have to report that we've disclosed information without HIPAA authorization. We don't have to go to the federal government. You don't have to talk to our privacy officer. So that's why it's super helpful and important and usually required to create a coding plan, because it means that we're protecting subjects better. Okay, that's all the things that I had. And I know this was a dense topic. Feel free to ask questions in an identifiable format or come up and ask questions afterwards. Yes?
One thing for clarification, when we were talking about verbal consent,
Yes.
like in a scenario where you have protocol amendments, you have a lot of patients that are in survival follow-up, long-term follow-up, and may not even live here, that you're just contacting by phone. And there's new risk that could come out that, the sponsor is requiring you to inform the subject of. That obviously it might be practical to do over the phone and require the written consent. But isn't it correct that you have to inform the IRB in advance that you plan in certain scenarios to obtain that verbal consent? You can't just do it.
So, yeah, it's a great point. So we're talking about a study where there's been some sort of modification, and the information that's changed is significant new information that may affect the subject's willingness to participate in the research study, which means that reconsent is required, and the IRB is going to require reconsent of those subjects. A lot of times, especially in your scenario, you mentioned that those subjects might be in long-term follow-up, they might not be coming into the clinic, or just the clinic visits are a long time apart, every 6 months, even sometimes every 3 months. We do get requests if we want to do verbal consent. That verbal consent does have to fit into the requirements that we just went over for waiver of documentation. So if we've increased new risks, we can't actually do a waiver of documentation, but we can certainly still facilitate phone consent, where you send the new information out to the subjects, they sign the form, you give them a prepaid envelope to send it back to you, or if they're coming in a certain amount of time, they bring that physical signature back to you. That still helps the subjects out, meaning that we're not asking them to come in for a unique visit for reconsent, but it also meets the requirements of documenting informed consent, and also allows you the flexibility of doing a phone call. So we still have to get written consent, but we can still do that via email, phone call, REDCap, any variety of ways.
But isn't it correct though that has to be identified and approved by the IRB?
Oh, yeah.
If you plan to do that as part of your plan, you can't just institute that on your own. It has to be kind of approved by the IRB as a method.
Yeah. So the question was, basically the method, or does the method of reconsent, or really informed consent, whether it's at initial review or throughout the study, does that need to be IRB reviewed and approved? Yes. So that's why on Form C, you should be specific that we're going to obtain informed consent in person. We may also do informed consent over the phone, and this is how we're going to make sure documentation is appropriate. We're going to use REDCap, we're going to use FaceTime, we're going to use Skype, anything. The IRB is okay with that as long as it meets the requirements for documenting informed consent. Yes, that does need to be reviewed and approved. Now, I just want to throw out one quick plug. If you've got new risks and you know that you're going to be submitting that as a UPERSO via a reportable event, You do not need to wait for IRB approval to inform the subjects of new risks. So if you know that this is a risk and you need the subjects to be aware of it immediately, tell them immediately. That does not need that can happen over a phone call because we want subjects to know that information as soon as it's necessary. Okay, thank you so much. We'll see you next month.